Hey, we're covering 25 questions you'll probably see on that Arizona real estate exam. You're welcome, my pleasure. My name is Robert Rico, head instructor here at US Realty Training. Remember, US Realty Training provides an exam prep package for students studying for the Arizona state exam, which comes with practice exams, terminology flashcards, video explanations, an ebook study guide, and a whole bunch more. Hey, listen. The link for that is in the description and comment section right below. So let's hop on to the student portal and take our exam. All right, now law based on customs and traditions is A, statutory law, B, administrative law, C, common law, D, civil law. Now there's a lot of laws out there, but which one does this apply to? Law based on customs and traditions. The answer is C, common law. Now, why is it common law? Let's look at the explanation. Common law is based on customs and traditions that have emerged from court challenges over the years. Got it? The Arizona Real Estate Commissioner, A, is elected every 4 years and can serve 2 terms. B, is appointed by the state Congress. C, is hired as a state employee. Or D, is appointed by the governor. That's a great question. And I want you to remember this one. The answer to this one is D, appointed by the state governor. Now why? Let's go to the explanation. The current governor appoints the Arizona Real Estate Commissioner and serves at the governor's pleasure. Nice and simple. So who's going to appoint the Real Estate Commissioner in the state of Arizona? That's right, the governor. An aggrieved member of the public, aggrieved meaning an angry or upset member of the public, may seek damages against a licensee via the Arizona Real Estate Recovery Fund only after A, proving damages, B, adjudication of the lawsuit, C, lis pendens, or D, the ADRE administrative hearings. All right? Pump the brakes a little bit. Think about this one. Somebody who's upset and wants to seek damages. The answer is B, adjudication of the lawsuit. Now, what does that mean? Let's go straight to the explanation. In order for a citizen to apply for relief from the ADRE Recovery Fund, her or his complaint must be already adjudicated through lawsuit and judgment. The Arizona Department of Real Estate will move forward if it determines the complaint did not receive enough damages to make him or her whole again. Then, the Recovery Fund may provide additional financial relief. Arizona is A, dowry and courtesy state. B, tenancy in the entirety state. C, community property state. Or D, Mexican land grant state. Great question. I want you to focus on the term community property state because that is the answer. The answer is C, community property state. Now let's go straight to the explanation. Now in the explanation it says, along with many other southwestern U.S. states, Arizona is a community property state. Now, community property meaning that when you are married, both of the partners in the marriage own the property equally. Community property, community property. In Arizona, guess what? It's a community property state. Cooperatives are A, freehold estates, B, leasehold estates, C, special forms of condominiums, or D, the same as communes. This is a nice simple question. Cooperatives is B, leasehold estates. Now why is it leasehold estates? Let's go straight to the answer. Cooperatives are rentals and thus leaseholds, which means what? You hold it as a lease. Got it? Nice and simple. While tenants receive stock in the company which owns the building, their individual apartment is not a freehold because it isn't purchased. The stock they receive is personal property, not real property. An action taken by the ADRE to immediately stop a licensee's activities which endanger the public health, safety, and welfare is called A, summary suspension, B, consent order, C, letter of concern, or D, surrender of license. While all these answers seem appealing, which one is the correct one? Here we go. The correct answer to this one is A, summary suspension. A summary suspension requires immediate stoppage of all licensed activities. It does not allow for the due process, meaning evidence, hearings, testimony, found in other license procedures because the licensee's actions are considered an immediate danger to public health, safety, and welfare. So the answer is summary suspension. In selling timeshares, real estate licensees must abide by certain marketing rules. Which of the following is such a rule? Now here we're focused on certain marketing rules. Marketing, all right? A, timeshare sellers cannot offer premiums. B, timeshare solicitors must register notice of intent to sell with the ADRE. C, timeshare sellers offering 2 or more timeshares for sale must complete a public report prior to selling. Or D, timeshare sellers are prohibited from offering high-pressure sales presentations. So let's go back to the question real quick. In selling timeshares, real estate licensees must abide by certain marketing rules. Marketing rules. Which of the following is a marketing rule? The answer to that is a marketing rule. The answer to that is B. Timeshare solicitors must register notice of intent to sell with the ADRE. So if they're planning on selling, they have to let the Arizona Department of Real Estate know about it. Let's go to the correct answer explanation. Anyone offering timeshares for sale or soliciting timeshare sales must register notice of intent to sell an application for a public report with the ADRE. A developer planning to offer 12 or more timeshare interval estates for sale, use, or lease in one project must obtain a public report before making offers for sale. Presentations and premiums are allowed. What is the primary purpose and function of an Arizona affidavit of property value? A, to warrant the result of a real property appraisal. B, to certify a given property's assessment as valid for tax assessment purposes. C, to affirm that a given property was in fact sold for the price indicated on the affidavit. Or D, to record the sales data of a conveyance and transfer tax payment responsibility to the buyer. Now, the answer to this one is, drum roll please, yeah, D. The answer is D. Let's go straight to the explanation. An Arizona affidavit of property value is used to record the selling price, date of sale, and other required information about the sale of real property. It is recorded simultaneously with any other deed transfer unless exempt. It transfers responsibility for paying property taxes from grantor to grantee. Grantor meaning the seller, grantee meaning the buyer. Part of a buyer due diligence is the responsibility to make a physical inspection of a property, which is known as A, a home inspection, B, an appraisal, C, actual notice, or D, constructive notice. Now, I want you to think about this. When a buyer is going to buy a property, in the process of purchasing a property, in escrow with a property, what should they do? This is almost a common sense question. Let's go through it again. Part of a buyer due diligence is the responsibility to make a physical inspection of a property, which is known as, you're right, A, home inspection. Let's go to the explanation. Buyer due diligence by contract requires the buyer to personally and physically inspect the property subject to purchase. It gives the buyer an opportunity to inspect that property and be satisfied with its condition prior to closing. Great question. Now you know the answer. Let's go to the next one. Which of the following is true regarding subdivision disclosure laws? Let me read that again. Which of the following is true regarding subdivision disclosure laws? A, they are examples of consumer protection laws. B, they are unnecessarily rigid. C, they are federal rather than state laws. Or D, they apply only to parcels larger than 160 acres. The answer to that one is A, they are examples of consumer protection laws. These laws are, any disclosure law is there and set there to protect the consumer. Disclose, disclose, disclose. Why? To protect the consumer so that the consumer is aware as to what they're purchasing. Let's go to the explanation on this one. Subdivision disclosure laws are designed to protect the public. There you go. Many Arizona real estate laws are specifically designed to encourage consumer protection. Disclose, disclose, and what's the third? Yeah, disclose. Which of the following is not a program area of the Arizona Department of Environmental Quality? A, water quality. B, air quality. C, waste. or D, wetlands? The answer to that one is D, wetlands. Now this one you'll have to memorize. Simple as that. There is no concept here, just memorization. The answer to that is wetlands. The correct answer explanation: the Arizona Department of Environmental Quality has 3 specific areas of responsibility: water quality, air quality, and waste. Wetland regulation and monitoring is shared by the state and federal government, generally under water laws. There you go. So Arizona Department of Environmental Quality consists of water quality, air quality, and waste, not wetlands. While finder fees are generally prohibited by law in Arizona, referral fees are allowed because A, they are broker-to-broker payments. B, the law allows licensed salespeople to share commissions with unlicensed people. C, only a licensee earns a commission. He or she can do anything he or she wants to do with it. Or D, it is allowed by administrative law. The answer is A. Referrals are allowed because they are broker-to-broker payments. Let me give you an example. I have a California license to sell property. I refer one of my clients to a real estate agent in Arizona. The Arizona broker and I myself, the broker here in California, are allowed to split commissions. That's okay because we're both brokers. Nice and simple. Let's go to the explanation on this one. ADRE prohibits licensees, meaning a real estate agent, from sharing commissions with unlicensed people, someone who does not have a license. It feels that if anyone can earn a commission, there is little incentive to get a real estate license. Referral fees are negotiated, earned, and paid between licensed entities. A finder's fee is one paid to an unlicensed person for new business leads and is prohibited. In Arizona, water rights are A, first in time, first in right. B, determined by property owners who own the water. C, federal. Or D, authorized by the U.S. Army Corps of Engineers. The answer to that one is A, first in time, first in right. Let's go straight to the explanation on this one. First in time, first in right is the basis for the doctrine of prior appropriation used in Arizona. Within a brokerage, who is charged with the responsibility for supervising all licensee advertising? This is a good question because when you get into real estate, you want to make sure you're not breaking any laws when it comes to advertising and marketing. So, within a brokerage, who is charged with the responsibility for supervising all licensee advertising? A, the employing broker. B, the designated broker. C, the office manager. Or D, the advertising manager. So whose responsibility is it? The answer to that one is B, the designated broker. Let's go to the explanation for this one. Arizona administrative law, commissioner standards require designated brokers to provide reasonable supervision to licensees under the brokerage's direct control. That includes responsibility for all advertising and promotion. No matter how modest the advertising effort, the broker should review and approve it. An example of stigmatized property is, now keyword here is stigmatized. A, one in which survey boundaries are in doubt. B, where an overpriced property for sale lingers on the market for years and years. C, a property believed to be haunted. Or D, a property with significant environmental damage. Now, when you think of stigmatized, I want you to think of something with a negative reputation, something haunted. Maybe there was a murder in a house, something unusually negative with a property. The answer to that is C, a property believed to be haunted. Let's go straight to the explanation. Due to the controversial nature of whether ghosts exist, the possibility of a property being haunted does not need to be disclosed. Most property disclosure focuses on material facts. An example would be something that's broken within the property. Which of the following best describes a planned unit development, also known as PUD? P-U-D. A new mixed-use development that is larger in scale and scope to a subdivision. B, a low-density subdivision with extensive common areas and open green spaces. C, a condominium development or building that conforms to municipal planning specifications. Or D, a conventional single-use subdivision of single-family homes? Let's go to the answer on that. The answer is A new mixed-use development that is larger in scale and scope to a subdivision. A planned unit development, also known as PUD, is larger than a traditional subdivision and offers mixed usages within several acres. Uses include areas set aside for residences, commercial uses, and public areas. Usage in PUDs tend to be high density, and the development attempts to maximize the amount of open space. PUD, planned unit development. The purpose of the Interstate Land Sales Full Disclosure Act is to A, ensure that buyers are aware of the property's value and highest and best use. B, promote transparency when recording the sales price and property condition. C, require registration of interstate land sale transactions. Or D, provide disclosure of public reports in order to prevent fraud. The answer to that one is D, provide disclosure of public reports in order to prevent fraud. Let's go to the explanation on this one. The Federal Interstate Land Sales Full Disclosure Act of 1968 was passed to regulate interstate land sales and prevent fraud and abuse in the sale or leasing of land. Its emphasis is on disclosure of public reports to out-of-state buyers. So anytime you see Interstate Land Sales Full Disclosure Act, I want you to think of disclosure of public reports in order to prevent fraud. Which of the following is true regarding pocket listings and coming soon listings? A, both a coming soon listing and a pocket listing are bona fide listings that have not been placed on the MLS. B, neither pocket listings nor coming soon listings is a bona fide executed listing agreement. C, a pocket listing does not allow co-brokerage participation while the coming soon listing fully authorizes co-brokerage. Or D, a pocket listing is with the converted for sale by owner seller, whereas a coming soon listing can be with any seller. I love this question because this is commonly mistaken in the real estate industry, misunderstood. The answer to this is A, both a coming soon listing and a pocket listing are bona fide listings that have not been placed on the MLS. They're actual contractual listings. It's not that I might get this listing one day. No, it's that you have the contractual listing already. So they are bona fide listings. Contract is in place. Got it? All right, let's go to the explanation on this one. There's a little difference between these two listings. The pocket listing is simply kept away from the MLS, which may violate MLS rules. And the coming soon listing may be advertised as a listing that will soon be placed on the MLS. Bottom line is this. When it comes to a pocket listing or a coming soon listing, the key word here is listing. When you have a listing, you have a contract, which makes it bona fide, makes it legal, means you're good to go. A judicial foreclosure proceeding is A, mortgage foreclosure, B, a deed of trust foreclosure, C, when a vendor-vendee forfeits, or D, a reserve bid. Here we're talking about a judicial foreclosure. The answer to that one is A, mortgage foreclosure. Let's go to the explanation for this one. In a mortgage foreclosure, the lender must get a court order to sell the property in default. It is a judicial procedure. A deed of trust foreclosure is non-judicial because the borrower has already given a trustee the power of sale in case of default. According to the Arizona Residential Landlord and Tenant Act, also known as ARLTA, security deposits may not be equivalent to what portion of the periodic monthly rent amount? A, 100%, B, 150%, C, 125%, or D, there is no limit. The answer to that question is B, 150%. Now let's go to the explanation on this one. If a landlord requires a deposit equal to 1.5 times the monthly rent amount as a security deposit and then collects the last month's rent in advance, the landlord is in violation of the ARLTA. Now why? Well, that's because the last month's rent is considered security deposit to assure the last month's payment. As a result, the landlord has collected more than 150% maximum amount allowed. A valid lease must be signed by A, both the landlord and the property owner, B, the lessee only, C, the lessor only, or D, the lessee and lessor? The answer to this is D, the lessee and lessor. Without both of them signing it, you do not have a valid lease. Let's go straight to the explanation. A valid lease must be signed by both the lessee and the lessor. In general good real estate practice and contract law, everyone who signs a lease or other real estate documents should receive a copy of it as quickly as possible. The answer to this again is D, the lessee and lessor. Which of the following is a valid requirement imposed on owners of vacation rentals by owner? A, owners must visibly display current certificates of occupancy in the rental premises. B, owners must comply with VRBO rules promoted by ADRE. C, owners must comply with the Interstate Land Sales Act via property disclosure reports. Or D, owners must register with the Arizona Department of Revenue and pay the appropriate state and local taxes. The answer to that one is, you guessed it, D. Owners must register with the Arizona Department of Revenue and pay the appropriate state and local taxes. The explanation for that one, owners must register their VRBOs with the Arizona Department of Revenue and pay taxes. In addition, the VRBO companies arranging matches between owner properties and users must now likewise register and pay taxes. What are group homes? A, properties designated as shelters for individuals suffering from addiction and victims of domestic violence. B, homeless shelters designated as such by HUD. C, properties occupied by a certain class of religious group, constituting an exemption from fair housing. Or D, blocks of identical homes in a newly formed non-HOA subdivision. Now, group homes are A, properties designated as shelters for individuals suffering from addiction and victims of domestic violence. Let's go to the explanation on this one. Group homes are often designated for victims of domestic violence and or recovering alcoholics or those addicted to controlled substances. Fair housing laws and Americans with Disabilities Act restrictions have largely made it unlawful to attempt to prevent designation of such homes for people in protected classes. The answer again here is A. Properties designated as shelters for individuals suffering from addiction and victims of domestic violence. Jennifer advised her clients they needed to paint their living room before showing the property, a very typical scenario. The walls of these rooms were all 8 feet high. The wall lengths were, one wall was 14 feet wide, another wall was 18 feet wide, wall number 3 was 16 feet wide, and the fourth wall in this living room was 18 feet wide. If a gallon of paint covers 200 square feet, how many whole gallons would the house sellers have to buy? Now, this is a fun math question. Might seem complicated, but we're gonna have some fun with this. Let's figure this one out, all right? Let me just paint the picture literally, huh? Let me paint the picture. Here we go. Wall number 1 is 14 feet wide. Wall number 2 is 18 feet wide. Wall number 3 is 16 feet wide. And wall number 4 is 18 feet wide. Now, all 4 walls are 8 feet high. Now, because we want to find out the total square footage of the total room of all the walls, I want to go straight to the explanation and get the answer there. Now, let's just focus on wall to wall, and then we're going to put them all together. Now, the first wall, if you look at the explanation, the total area of the living room is, first wall is 8 feet by 14 feet. So we got to multiply those two. The second wall is 8 feet by 18 feet. The third wall is 8 feet, and we're going to multiply it by the width, which is 16 feet. And the fourth wall is 8 feet, and we're going to multiply it by 18 feet, the width. When you add all these walls together, you get 528 square feet. That's your total amount of square footage for all 4 walls. Now, if 1 gallon of paint only covers 200 square feet, we would need 3 of these, 3 whole gallons to cover all of these walls. So the answer then would be C, 3. We would need 3 gallons. An investor just purchased a rectangular 2-acre retail lot for $250 a frontage foot. If she paid $100,000 total, what was the depth of the lot? This question could be confusing. Relax, let's figure this one out. Answer A, 400 feet. B, 250 feet. C, 871 feet. Or D, 218 feet. Let's go to the explanation on this one. Again, we're looking for the depth of the lot. Now, explanation. Since the investor paid $100,000 total, and that equals $250 per frontage foot, there are 400 frontage feet, which is 100,000 divided by 250. If the property is 2 acres, it totals 87,120 square feet. Divide this by 400, produces a lot depth of 217.8. And that's 25 questions for the state of Arizona. If you want to make studying for the real estate exam easy, like really easy, then get our real estate exam prep package. You get practice exams just like this, flashcards to study vocabulary terms, video explanations to learn concepts, and an ebook. Yeah, an ebook study guide to show you everything that you need to study for. If you want another video just like this one, then check out this video right here, right here. We'll see you next time.